Yes, I salute you all. Thanks for listening and thanks for watching. Subscribe to the channel, like the videos. So basically today we are under criminal law, and the topic of emphasis, or the topic that we are going to insight specifically, we are going to deal with parties to a crime. Parties to a crime or partners to a crime. Partners in a crime. Actually, there is a Latin maxim that is good, which is called that percips criminis. Basically, that is calls that they are partners to a crime, and everyone is liable once you partner in a crime, or once you part to what, to a crime basically. And either when you follow section 20 of the PCA Penal Code Act calls for that anyone that gets involved in the commission of the offense is what, is liable, and the punishment is under section 21 of the Penal Code Act. But it starts from section 19 of the PCA. Basically, here what you have to know about partners to a crime or parties to a crime, we have what they call the perpetrators. Perpetrators, basically, they can also to mean as the principal offenders. Those ones are the perpetrators. We have the principal offenders or perpetrators, we have the aiders, we have the abettors, we have the procurers, we have the counselors, we have the what do they call them? Accessories. Accessories before the fact and accessory after the fact. So basically, we shall start with the perpetrators or the principal offenders. The principal offenders, basically, these are the people that get involved in the commissioning of the what? Of the crime or the offense. When you read section 20 and you correlate with section 19, realize that for a perpetrator to be called a perpetrator must be a principal offender, and the principal offender to be called a principal offender must have been in the commission of the what? Of the crime. Take for instance, if it is murder, and murder is out of stabbing, that person specifically caught the knife and pierced the what? The other. Basically, not that in what? In mind. You get, the principal offender is the person that holds the knife and pierces the what? And stabs the other. Or if it is commission of rape as an offense, is the one that got his penis and penetrated inside the vagina of the what? Of the victim. So that is the principal offender. There is a case of Ara versus Michael. That is a good case. Under this case of Ara versus Michael, realized that here the mother of the baby told the nurse to give poison to the baby. However, the nurse didn't know that it was poison. So later in the day, the nurse failed to do what? To administer poison and put it on the shelf. So when it was placed on the shelf, the child came playing and found the poison on the shelf and administered it to the baby, of which the baby afterwards what? Died. So the case was that who was the perpetrator in this case? Case held that the mother was the perpetrator. Reason being that however much is known to the one that who commissioned, but however he was a perpetrator. We have two categories under perpetrators. We have the primary offenders and the secondary offenders. So in this essence, he can be categorized as the principal. You understand? Those who know agents law very well can be categorized as the what? As the principal. So basically note that in mind, or bear that in what? In mind about the principal or the perpetrators. You get, principal offenders. Then we also have what they call an aider. You get, and before even going to an aider, basically what you have to know, the abetter, abetter and an aider, basically most so they are normally at the scene of crime. Procurer, counselor, for them, and the accessory after the fact, they are normally not at the scene of crime. Basically, note that in mind. Counselor, procurer, and the accessory after the fact, they are normally not at the scene of crime. So note that in mind. So basically, we shall go to aiding, who is known as an aider. Section 19 provides for who is an aider of the Penal Code Act. So basically here what you have to note in mind, or what you have to bear in mind, when you read the case of Ara versus Kogan and Link, provides who is an abetter, who is an aider, basically. An aider, basically, in the layman's understanding, what I can tell you that an abetter is the person who aids. As you get the explanation of someone who aids, it can be someone who watches over when you are commissioning the what? The offense, or someone who basically basically, as if it is robbery, you are robbing, but someone is watching over to see if there is any guard coming. That is an aider. He's extending that assistance or that help. You get, extending that assistance or help to you. You get. Before even there's that case of Uganda versus Ambayo and other. That case talks about that anyone can, once you are party to a crime, or once you are partner, you have got involved in the commission of the crime, you can be what? Liable. You understand? Following section 21 of the Penal Code Act. So basically that's the aiding, basically what I've provided for. Aiding basically, and also aiding does not necessarily mean that you can be at the scene of crime, basically. Because if I'm stealing and you are somewhere watching, you are an aider. You understand? You are like helping, you are engineering my commissioning of the what? Of the offense. You get? You are watching if the guards are coming. You get? So you become an aider. The layman is what? Understanding. And there is also what you have to know, or what you have to bear in mind, that's aider. Then you go to an abetter. Abetting, basically, to abet is to encourage. You understand? To abet is to encourage, basically. Basically, that's what you have to know. To abet is to encourage. Also, that case of Ara versus Kogan and Link, it is a good case on abetting. Abetting basically may mean if you're a security guard. This is the good example. If you're a security guard, people are stealing, but as you are coming, for you just watch them carrying out their what? Their theft, and you just what? Leave them and do what they want. Basically, you become what? You become an abetter. Basically, not that in what? In mind. So that's why you realize that in this essence, you realize that abetting and aiding, they have one difference. For aiding, it is necessary that you have to be at the scene of crime by the time the commissioning on the offense. But for the abetter, you have to be at the scene of crime. That's why abetting may also, to encourage, is like you give green light to someone's act. I've given an example of a security guard watching people stealing but has nothing to do. You understand? That is to abet. And also to abet, it can also mean that you have encouraged someone, you have advised someone to continue with the commissioning of the what? Of the crime. At the scene of crime, basically not me very well. You have encouraged someone to continue with the commissioning of the what? Of the crime at the scene of crime. Then there you are what? You are abetting. You understand? Follow section 19 of the Penal Code Act. Basically, note that in what? In mind. I've given you the difference between abetting and aiding, but for them, all of them, they are normally at the scene of crime. But for abetting, basically, you must be at that point whereby they are commissioning the what? The offense. You get? So basically, note that in what? In mind. There's also a good case of Uganda versus Odiambo. Odiambo, basically. Uganda versus Odiambo. It differentiated between an abetter and what? And an aider. So that is a good case that differentiated who is an abetter and who is what? An aider. So basically, note that in what? In mind. And here what you have to know, or what you have to relate in mind, is that you must know, for you to use these parties, to know the person in the commission, that partner in the crime, who is he in such matters. Understand who is an aider and who is the abetter. Understand who is the principal offender. You get? So basically, note that in mind. Then we have what they call a procurer. You understand? A procurer in this essence. Basically, what you have to know about a procurer, A procurer is someone who manufactures something that helps in the commissioning of the what? Of the offense. That is the procurer. That's why they say procurer normally is not at the commissioning of the what? Of the offense. Is an accessory before the fact. That is a procurer. So note that in mind. Is an accessory before the fact. And the procurer in this understanding realize that he manufactures something that helps in the commissioning of the what? Of the offense, basically. And the procurer, basically, there is this case of Attorney General reference case of number of 1975. Basically, here the accused person put some toxic liquids in what? The other one, the accused person is drink. So the accused, after he got drunk and went on driving, so was arrested for being drunk while driving. But however, realized that here the person that was being accused of procuring was this one that incited the alcoholic fluids into the person. This person is what? Drinks. You get. At first he pleaded not to be guilty, but court later went deep and discussed his matters, whereby they said that the fact that he knew that this person after drinking is going to drive, he becomes a procurer. A procurer must manufacture something with actually knowing or having in mind what is going to take place after. So he was held liable for being a procurer in the commissioning of the what? Of the offense. That is a good case on Attorney General's reference case of number 1975. So basically, not in what? Not that in mind, basically. That is to do with the procurer. Then after procurer, we have what they call an accessory after the fact. What do I mean by an accessory after the fact? Basically here what you have to bear in mind, or what you have to put in mind, is that an accessory after the fact. Here I realize that here basically what you have to know is that the fact has already been committed. You get, the fact has already been committed, but realize that a person is participating to the people that committed, now is helping them in some other way. You understand? To make the fact successful at the end. You get, a good example is that if someone steals a bank and when he runs away, you hide that person in your house. You understand? You fail to give him to the courts of what? Justice. So you become an accessory after the fact. You get? So basically that was better explained in the case of Davies versus DPP. That case explained who is an accessory after the fact in that manner. It explained who was an accessory after the fact, in a way that for you come after the commissioning of the what? Of the crime. You get, you come after the commissioning of the what? Of the crime. Basically, that is an accessory after the fact. Then we have also a counselor. You understand? A counselor is an accessory before the fact. Basically, note that this in mind. A counselor is an accessory before the fact. You get? I've given you the highlight between an abetter, aider, principal offender, accessory after the fact, a procurer. You get? Abetting is to encourage. That's why I say that for abetting you can give guidance, or you can instill someone to move forward once you are the scene of crime, basically. And under abetting you can also cancel, but you cancel at the scene of crime. It's like when I find someone stealing, I tell him or her, you steal, you are abetting, you are encouraging. But here a counselor comes as an accessory before the fact. So these are some of the things of a counselor, whereby you realize that a counselor comes in a way that he can advise you that, you know what, you want to steal a bank, but you try Mapera, that branch of Centennial that is at Mapera. You want to steal this one, but at least you can actually, he's instilling what you commission after. But the fact here, what you have to prove is that the commissioning of the crime, it must have been directed from the counselor's what? Advice. Basically, this is what you have to prove. It must be from the guidance of what? Of the counselor, for you to prove that he's a counselor in that manner. You must prove that in the relation, or what related is that what I did, or everything that I did, I based on the counselor's guidance. There is a case of R versus Calhem. Under this case, this defendant hired what? A hitman. Hired a hitman. So he had a hitman to kill the what? A certain lady. So when this hitman was hired, he reached there. Actually, he went with a gun and a hammer. But for him, he said that going there, I'm not going to kill the lady. You understand? That's why he went with the gun with no bullets, and he went with the hammer. For him, he said that I want just to show that I went and tried to carry out my what? My duty. So after reaching there, the lady actually screamed over, shouted over. When the lady screamed, so this hitman felt furious and reacted and hit the lady with the what? With the hammer. You get? So afterwards, court brought the defendant to court, holding that he was a counselor with the commissioning of the what? Of the offense. He was denying, but however, the fact that however much this person that committed the offense claimed that he wasn't going to kill the lady, but however, realized that the commissioning of the crime that he later did based on the counselor's what? Advice. You understand? He was directed by the words of the counselor to kill the lady. So the person was held liable for being a counselor in the commissioning of the what? Of the crime. So basically not that preference. A counselor is normally not at the scene of crime. A counselor is an accessory before the what? Before the commission, is an accessory before the fact. You understand? So I've realized that we have categories. We have accessory before the fact. We have accessories during the fact. We have accessories after the fact. So basically note that in mind. And basically those are the parties to what? Parties to a crime. Or they are called partners in crime. And their punishment is under section 21 of the Penal Code Act. But other than that, thank you for watching. Subscribe to the channel, like the videos, share, comment the questions that you feel that you are not well versed with, so that we can mitigate and we analyze them so that we can understand the law. But thank you for watching. I wish you good luck.